We get a lot of phone calls at the NOTO office from folks wondering if they're going to have problems crossing into Canada from the US because they've got a DUI or some other minor criminal matter in their background somewhere. And there's been a lot of confusion about this issue, a lot of stories and myths and legends about what it takes or how hard it is to cross the Canadian border. Let me try to give you a really quick overview. Under Canadian immigration law, someone who has a criminal record of any kind, including a minor criminal record, can be deemed inadmissible and denied entry to Canada. And where we see this most often is with people with DUIs, DWIs, what we would call impaired driving in Canada, on their record. So the first thing you need to know is those things show up because they're treated as criminal matters, both in Canada and the US, not as strictly traffic matters. So you don't need to worry about things like speeding tickets and unpaid parking fines or any of that sort of thing. DUI shows up because it's considered a criminal matter, as would an old marijuana possession charge from your college days or an assault charge as a result of a barroom brawl or any number of other things. So what they check when you get to the border, if they choose to do a secondary check, is a check of the FBI criminal record database, the database known as NCIC, National Crime Information Center. So you need to know what is or might be in that NCIC database. Sometimes you know pretty clearly and you've got a clear recollection. If you don't, or there's some question about whether some charges were dropped, you may want to check with local law enforcement and see if you can actually find out what's in the criminal record database. So once you know what's there, a couple of questions that you need to ask yourself to help figure out your admission status. So, is there something in the criminal background check? If there is there more than one thing? And how long ago did those things happen? Those are going to be the two key questions you need to be able to answer. Let's start with the simplest one. There is a single thing, say a DUI, and it's 12 years old. Well, more than 10 years has passed from the time of the offense. It's only one thing on your record. You are in fact fully admissible to Canada. You are deemed rehabilitated. So a single minor offense, more than 10 years old, kind of gets a free pass. You have to disclose honestly at the border, but it shouldn't provide you any problem. Now, as a result of a very recent change made in March of 2012, even folks with a single minor offense less than 10 years old, in fact, even up to very recent, will generally be allowed admission. They'll be allowed in under a permit called a temporary residency permit. It'll be offered at the border. Customarily, there was a $200 charge for that, but under this new initiative, the $200 fee is being waived. So even a single recent offense, you will be able to enter Canada at least once. Your status after that first admission is still not clear. It's a brand new initiative, and we're not sure how they're going to interpret that. So now let's look at the other case. You have more than one thing on your record, or the one or more things you have on your record are less than 10 years old. At this point, the magic number becomes 5 years. So if the most recent offense is 5 years old or older, whether single or multiple, you have to apply for what is called granted rehabilitation. You have to fill out some paperwork, provide some documentation, some court documents, a criminal background check, submit those to one of two Canadian consulates, depending on whether you live in the eastern or western US. So you submit it to either Washington, D.C. or Los Angeles, and this process will take some time. There will be a $200 fee to the Canadian government, and the process may take a year or more to complete. However, once that process is underway, there's another way that you can enter Canada if you're planning on doing a trip sooner. You can start that process, present at the border, and ask for admission under a temporary residency permit. Given that you've applied for rehabilitation, you appear to qualify. Although these are issued on the spot at the border, generally they're looked at pretty favorably if you've got a rehabilitation application in the system. The bad news on that one is that TRP will cost you an extra $200. But if it's a trip that you've already planned or you're really eager to complete the trip, many folks have indicated to us that they consider that an acceptable price to pay in order to be able to go ahead and complete a trip while they wait for their rehabilitation application to be completed. Once that application is completed, you get a letter of rehabilitation that indicates that you're fully admissible to Canada, and you won't have any further problems in the future unless, of course, you do something bad again and put something else on your record. So, basic overview, most important thing to do To start out though is figure out what your actual status is. What's on your record, how many offenses, how long ago. From that you'll know how to proceed. You'll find more information about all of this, including a simple flowchart to help determine your eligibility on our website. And if you're still confused, you can always call our office for more information.